Every law enforcement officer must understand the criminal laws they enforce. The deeper this knowledge, the more effective an investigator can be. Criminal law forms the foundation of every investigation, and this principle will be reinforced throughout this text. Criminal law has two main parts. Substantive law defines what constitutes a crime. When an investigator gathers enough evidence to meet these legal elements, a crime is said to have occurred. Procedural law, on the other hand, governs how investigators interact with victims, witnesses, informants, and suspects. It sets the rules for what can and cannot be done during an investigation, covering arrest, search and seizure, interrogations, confessions, evidence handling, and court testimony. Procedural law changes more quickly than substantive law. Other chapters cover specific legal topics in detail. Chapter 5, Interviewing and Interrogation, addresses the rules for interrogations and confessions. Chapter 22, The Trial Process and the Investigator as a Witness, focuses on evidence admissibility and testifying in court. This chapter concentrates on arrest and search and seizure. But to fully understand these topics, students must also grasp the historical constitutional principles that shape current law. The Constitution created a national government from powers granted by the states, but ratification required assurances that individual liberties would be protected. The Bill of Rights sets out key protections, and the Fifth Amendment's Due Process Clause, "Nor shall any person be deprived of life, liberty, or property without due process of law," remains central, though its exact meaning has long been debated. Police must disclose to prosecutors, and prosecutors to defense attorneys, any evidence that could question the credibility of witnesses or officers. This Brady material protects suspects' constitutional rights, and failure to disclose it can lead to case dismissals and civil liability. Following the Civil War, the 13th, 14th, and 15th Amendments guaranteed freedom and equal protection under the law, particularly for formerly enslaved people. The 14th Amendment underpins much of modern criminal procedure in the United States. The Fourth Amendment protects people from unreasonable searches and seizures and requires warrants based on probable cause, specifying the place and items to be seized. An arrest involves taking a person into custody based on sufficient evidence for prosecution. Three key elements define an arrest: intention, authority, and custody. Detention is a temporary, limited interference for investigation, commonly a stop and frisk. Officers may pat down outer clothing if they suspect a person is armed. Arrest does not automatically mean the person is formally charged. Charging follows a prosecutorial decision. Arrests can occur in the following situations. 1. With a warrant. 2. When a crime occurs in an officer's presence. 3. When probable cause exists for a felony, or 4. In specific statutory situations. A warrant is a judicial order supported by an affidavit describing evidence and directing an arrest. The Fourth Amendment requires that a warrant for an arrest, which is a seizure, be based upon probable cause. Probable cause is a legal standard that requires enough evidence to lead a reasonable person to believe that a crime has been, is being, or will be committed. It serves as the foundation for both arrest and search warrants, and it also permits police officers to make arrests without a warrant if they personally witness a crime taking place. This standard is stronger than reasonable suspicion, yet it does not demand absolute certainty of guilt. At the same time, probable cause falls short of the higher threshold of proof beyond a reasonable doubt, which is required for a criminal conviction. The Fourth Amendment permits searches and seizures by government agents, usually requiring a warrant. A search warrant, issued by a judge on probable cause, directs officers to seize specific property. Courts recognize several exceptions when officers may search without a warrant. Some of these exceptions are as follows. Search with consent. Consent allows a search if a person voluntarily agrees. Refusal does not constitute probable cause. Search incident to arrest. Officers may search an arrestee for safety and to preserve evidence. Motor vehicle searches. In the case of Carroll versus the United States established the movable vehicle exception. In New York versus Belton, the court allowed searching a vehicle's passenger compartment during a lawful custodial arrest. Exigent circumstances. Warrantless searches are allowed in emergencies, such as risk of flight, destruction of evidence, danger to the public, or hot pursuit. Inventory searches. Agencies must inventory property taken from arrestees to protect and document it. Plain view. If evidence is in plain view while officers are lawfully present, it can be seized. Stop and frisk. Terry v. Ohio allows officers to frisk for weapons during detention. Contraband discovered if immediately recognizable as non-weapon may be excluded. Minnesota v. Dickerson. The exclusionary rule is a legal principle that prohibits the use of evidence obtained through unlawful searches or seizures in court. Not only is the original illegally obtained evidence barred from being introduced, but any additional evidence discovered as a direct result of that unlawful conduct, often referred to as the fruit of the poisonous tree, is also generally inadmissible. Please use this sway as a supplement to your reading material. Your textbook contains a wealth of valuable information, and Professor Reese and I would hate for you to miss out on it.
Have a wonderful day.